Good afternoon, everyone, and good early evening to those of you that are dialing in from the UK and the EU. Thank you for finding some time to spend with us today. It's a joint effort from Venable and Fieldfisher, two firms that have known each other and have worked closely for a number of years on a host of different client matters. I'm Ashley Craig. I am the chair of the firm's International Trade and Logistics Group at Venable. And I am joined today by my partner, Shahin Rothermel, who is a partner in our advertising and marketing law group, and then Andy Hood, who is partner and head of international trade at Fieldfisher. So we're approaching this literally from both sides of the Atlantic, as you might imagine, given that we're going to drill down on the new U.S. UK trade agreement. Couple key points at the very beginning. The three of us who've been talking and planning on this presentation for the last month or two would like to approach it in a cooperative, open, and frankly conversational manner. So we're going to try to refrain from too much of the lecturing and the reading off of the PowerPoint slide deck and engage in some witty commentary and banter, especially from Mr. Hood. We're going to cover today not only the agreement and what we know about it, which is frankly bits and pieces as it still continues to be refined and eventually implemented. We're also going to take a step back at the very beginning and talk about U.S. trade policy since January 20 and how we've gotten here to the extent that we can articulate how. We're also going to discuss some open issues between the U.S. and the U.K. And then we're going to hear from Shahin, who's touching on some interesting and frankly, at this point in time, really not thought through issues of how the tariffs and the trade policies are interacting with marketing and advertising concerns. And then the last thing we're going to try to do is go through collectively a host of practical issues that you may already be thinking about. And if not, hopefully you'll walk away with a better understanding. We'd love to say that we have the answers to the questions, but to be quite honest, we don't have the answers to all the questions, but we'll do our very best to walk through some practical, contractual, commercial issues that are flowing from the U.S. trade and tariff actions over the last several months. So before we jump in, Shahin or Andy, anything on your side that you wanted to say at the beginning?
No, not particularly. I'd just say hi and thank you all for joining, and thank you particularly to the Venable team for helping to organise all this. I think the only point to make as well, I think, is just to emphasise what you were saying at the start, Ashley, which is although this is of the UK, billed as the UK-US deal, and we will look at that, of course. Actually, I think a lot of what we want to look at, particularly from a practical point of view, is what the wider impact of US tariffs, which frankly not only affect the UK, but the EU and sort of global trade more broadly. And perhaps with that, and to pick up on your entreaty to make this more conversational, given I've not looked at the news feed for the last 6 minutes, and given how things are variable on your side of the pond, just what's going on? Tell us.
Just throw me into the deep end. I got that. Thank you for setting that perfectly up, Andy. Let's start with what we do know, and frankly, I don't think anyone should be surprised if you even remotely followed last year's presidential campaign. Frankly, if we go back in time to when Mr. Trump was elected the first go around, I think everyone on this call clearly interested in trade, tariffs, and how they impact commercial concerns. And I would note that we have a very vast and diversified group of attendees covering a lot of different sectors, industries, service, as well as tangible products and manufacturing. So a good representation of how important trade, of course, is across borders and has been for decades. Long way of saying the president entered the first term fixated on China and disrupting the U.S. supply chain sourcing apparatus between the two countries. And we could debate whether that was successful or not, but he did use a series of tariffs primarily designated against China to try to, quote, resource nearshore or move U.S. production and sourcing out of mainland China. And I think it's debatable as to how effective that was. But a key difference between then and now is he was mostly focused, although not exclusively, on China. He went after steel and aluminum, which included the EU, the UK for a period of time, as well as Japan. Um, but again, he was primarily concerned and obsessed with China. Obviously, that hasn't changed because we find ourselves now looking at over 145% tariffs on Chinese products, which is substantially X times what we saw the first time around. But again, to your point or your question, Andy, we have a president who, setting aside whether you support his policies on trade and tariffs, is doing what he said he would do. It was fairly well scripted, and he is trying his best to follow through with those promises. He loves to say promises made, promises kept. So, with regards to the tariff activity since January, and we'll get into that in a minute, but he has signaled that he wants deals across the board. And in fact, yesterday, the U.S. Trade Representative issued a pronouncement saying every country that we're currently in discussions with, and if you believe the president, it's over 90, you have until tomorrow, Wednesday, to put your best offer on the table, and we'll take a look at it and then we'll go forward. We're halfway through the 90-day pause in the so-called reciprocal tariffs, which we'll talk about in a moment. But the long and the short of this is that the president and his trade team are moving forward as they indicated they would do during the campaign, and they moved very quickly. It was a matter of a couple weeks after Inauguration Day that we saw the very first round of tariffs hit. So that's my feeble attempt to answer your question, and I'll do my best to continue throughout this presentation, Andy. But I we'll tip it to you to see if you wanted to comment here. We have in front of everyone an overview slide of traditional U.S. UK trade issues and barriers, and what we source from you and what you source from us. Apparently, we both like to make power generators. I did not know that one, and we're sourcing from each other. So I go figure. But and I should also note that Andy did spend time within the central government and worked on trade policy for a number of years. So he has that unique perspective. Not to put you on the hot seat, Andy, but just tip it to you for any general comments here.
Yeah, I mean, I'll resist the temptation because although, I mean, I did spend a lot of time in central government looking at trade policy, I also have the UK government as a client on the trade deals. Not this trade deal, I have to say, but on others. So I'll resist the temptation to comment too broadly. But you raise a good point, which is there are key areas, and I think the slide picks up where the UK, US have particular sort of intersection of their trade, and the EPD, the Economic Prosperity Deal, the UK-US deal, is designed to address some of those big issues that are facing the two countries. Frankly, is also clearly a political win for both sides, for the president in terms of his trying to get other deals with other countries on the back of the tariffs he announced, and for the UK to try and ameliorate some of the difficulties of those and earlier tariffs. So, yeah, I think that's what's worth exploring going forward. But I think the slide just helps give a flavour of that sort of those key intersections, and that's where we see a lot of the negotiation coming in the course of the last few weeks, and no doubt going forward, given some of the holes that are still there to be plugged.
Thank you, Andy. I think we can advance to the next slide. So this is a continuation of Andy's request to explain how we gotten to this point in time. A quick summary. It's quite interesting when you crunch the numbers that the effective U.S. average tariff rate is now 20.7%. That's the highest since 1910. And for those of us who are appreciative of history will know that at that point in time, Even though there was cross-border trade activity, the U.S. was still pretty much in an isolationist state of mind. That's pre First World War. And as I think we all remember, we didn't enter right away. But the trade at the time reflected the fact that the U.S. was still pretty much an island in and of itself. Liberation Day, which is what the president proclaimed, and that was when he announced the 10% baseline tariff attaching to every trading partner of the United States, and then so-called reciprocal tariffs. Reciprocal tariffs, from the president's perspective, is a line by line, tit for tat response to how certain countries have been approaching U.S. exports for years, decades, arguing that there's an imbalance and the reciprocal tariffs would help to correct that. He made the announcement, the markets tanked, there was great concern, and within a matter of days, he hit a pause for 90 days on the reciprocal tariffs, except for China. We also have other matters in which the president is exercising authority. Again, we're going to try to not dive too deep into all of this and focus more on the practical realities for you. But it is important to note that the president has been using the so-called International Emergency Economic Powers Act, or IEPA, to impose most of his tariffs. And why? The answer is it's quick. He does not have to wait. He doesn't have to provide notice. He has to declare a national emergency and technically confer with Congress. The first time that he did this was not in the first term. He tinkered with it. He threatened to impose IEPA tariffs on Mexico, and then he got the Mexicans to come forward and redo NAFTA. But in this second time around, he invoked it to impose tariffs on China, Canada, and Mexico early in the term, and he did so by signing the fentanyl crisis and attaching it to all three countries. There was a pause, not for China, but for Mexico and Canada to some extent. But the takeaway here is that the president is very focused on using the IEPA authority. Now, it has been challenged. As you can see, there are multiple lawsuits that we identify in the latter part of the deck here. 7 states at least have filed suit against the administration. Just yesterday, a case that was brought by toy manufacturers in Washington, D.C. District Court found that he does not have the authority. You may recall that just a few days prior, the U.S. Court of International Trade, which is a specialty piece of jurisdiction overseeing customs and trade matters, ruled against the president on IEPA as well. That has been paused. It's now being pursued through the appellate process, which we all know this is going to get to the high court. The Supreme Court is going to eventually have to deal with these issues. And then we just have to wait and see, frankly, what happens on the other fronts. There are other investigations that they have launched under Section 232. Steel and aluminum, for example. He's also announced that he's taking the 25% up to 50% on steel and aluminum across the board as of tomorrow, but there hasn't been a lot of additional details released by the White House. So we believe that we'll have a proclamation that'll come down, and that the new tariffs will go to, again, 50% come 12:01 a.m. tomorrow. In terms of the UK, uncertainty there as to whether, notwithstanding this new trade agreement, that the 50% steel and aluminum would hit UK production as well. We're just not certain. So stay tuned on that one.
Actually, just to dive in, like, as I'm a bit loath to, if we can stay on the previous slide, as a sort of non-US lawyer and non-US counsel advising on this, and you are the experts, but as a sort of non-expert, I remember, a month ago, the beginning of the pause, 45 days ago, a lot of clients just almost throwing up their hands thinking, well, what on earth do I do and how does it work? We had baseline tariff, reciprocal tariffs that were going up, then they were doubling, then they were halving, then they were being paused, then you had then there was these exemptions. Everyone was very excited if they were in a section that was part, or a sector that was part of the exemption, because they thought they were free of the sort of up and down tariffs. Right. And then actually what we sort of saw this is where I started to learn a lot more about the US side, was this sort of more systematic approach. All the things that have been exempted, apart from perhaps a few products, many of those sectors then becoming subject to Section 232 investigations and duties potentially down the line. So the sense that maybe you're all exempt and it was great, um, I think is then being set aside, or people are revisiting that with the Section 232 analysis. And then rather than simply think, oh, it's all too difficult and there's not much I can do, actually the point about engaging with, at least for non-US or for US for suppliers into the US, so for us Brits and for others around the world, actually to engage with your customer base if you're in one of those Section 232 sort of sectors, so that they can start to engage on the constructive specifics of it, because actually there is a chance to engage. That was one of the sort of big things I learned about 2 months ago. But just to kind of give it a bit of context for us who are not as familiar with these different types of tariff measures.
That good points, Andy, and happy to spend a little bit of time on that. So yes, outside of the IEPA approach, which is essentially again his favorite and it's effective immediately, and he, in his view, can do whatever he wants once he declares an emergency. If you're looking at the other authorities that have been delegated to the president through statute, so Section 232, Section 301 investigation, those all are public notice and comment. It's overseen in part by the Commerce Department, 232, USTR, 301. So these are well-established trade regulatory agencies that have been around for decades and have survived. I must say, the Doge, Mr. Musk's attempts, they have been hit to some extent, but for the most part, first of all, USTR is a relatively um, streamlined association of professionals that have been there for a number of years that are typically nonpartisan. There are political appointees there too. Commerce, that agency has been around for eons and is one of the largest agencies, I think 40 to 50,000 plus. So they have survived the streamlining effect and are doing their best in this very upside down environment. But to your point, if new investigations are launched, other sectors, there will be an opportunity to prepare and file comments and to appear before the agencies if there are public hearings. We have a steel and aluminum ongoing matter. As I said, he's already looked at it the first term. There have been determinations, and as we understand, tomorrow, if it does happen, he's just going to move up that tariff. So there's very little that can be done there in terms of the private sector participation at the moment, with a caveat that I'll hit on in a second. There is also an investigation looking at lumber, timber, and derivative products, which would cover not just our trading partners in Canada, which is a prime source of Canadian softwood lumber, but lumber everywhere and anywhere. That one also is on the way. Comment period has come and gone. We believe that a determination will be made by the administration at some point, probably over the summer. If you look at the first term, these investigations usually ran 10, 12 months. And we know that the president was frustrated with that process. Section 301, same thing with regards to the first batch and then the subsequent rounds of tariffs on Chinese produced products. So you are right to flag it in terms of a possible way to participate going forward. I would also note that to the extent you're a member of a trade association, so from the UK side, even if you're not in the US, you still have an opportunity to engage in constructive, I would say, hate to use the word lobbying, education perhaps, engaging in direct dialogue. The administration has opened up initially for the first couple of months. They didn't want to meet with trade associations, not across the board, but for the most part. They now seem to be more engaged and are sitting down with stakeholders. If you're part of a U.S. trade association, you name it, you pick it, the Chamber, National Retail Federation, the list goes on and on. They have been very active and will remain so on trade issues. So one of the things that we'll talk about a little bit later is, your industry, and it's important to, if you have the opportunity, demonstrate that, look, I cannot source from another country other than A, B, C, and D. There is no U.S. domestic capability to produce that. So I'm really attached to this sourcing methodology. I'll do my best. Um, we know that some sectors have even said we'll look at potentially nearshoring and producing in the U.S., which is what the administration really is looking for. Uh, this is all based on the first term when, under the Section 301 proceedings, there was an opportunity to submit a request for an exclusion. And to demonstrate that you qualified, you had to argue, I can only source from China. There is no U.S. domestic capability, or it's minor, and it will not meet the consumption demands of the private sector. And I'm open to considering reshoring or nearshoring or outsourcing from China, but I need time to do it. And ultimately, it was a decision of the administration whether to grant those exclusions, and many were, in fact, granted. So there are options. We should try to remain as positive as we can here, but at the same time, there are a lot of open questions. So Andy, I don't know. This is just an overview of the deal itself, and I think it's important to note that when Liberation Day did come, um, the UK, as I understand it, was already pretty far along with the talks on the US side, and thus the reciprocal tariffs did not apply to UK products. The 10% baseline across the board did, but the UK did avoid any additional higher reciprocal tariffs.
Yeah, I mean, I think the well, don't quite know how we escaped it because I'm not entirely sure of the approach that was adopted in terms of applying the other tariffs across the rest of the globe. But I mean, the UK and US have been trying to get a trade deal in place for well, ever since sort of Brexit, our own liberation day came, as some people put it, and that just hasn't happened. So I think what we've seen, number one, is the fact that the sort of the trade deficit between the UK and the US just isn't what we see elsewhere on the sort of Trump analysis. I think in terms of those trade figures, looking at goods perhaps less than services. And number two, as they were looking to try and find some deal, obviously it's a political win for the Trump administration, and the UK, as they obviously would have thought it got some good outcomes as a result of this deal. But I think you'll probably see chunks of that taken from the negotiations that would have been happening already. We see a sort of a flavour for what the Trump administration might be trying to get with other countries around the world. And from the UK-US deal in particular, and perhaps if we just hop onto the next slide, I think it covers a whole range of different areas, from obviously the tariffs, which we know very well, but also non-tariff barriers. And there's lots of the stuff that you might see in a normal trade deal about sort of good chat about the future cooperation and future analysis of either trading goods or the digital tax issues or other matters around intellectual property rights and similar. So it feels to me that they've taken the husk of negotiations that were happening and may have not applied across the board as we've seen a full trade deal, and they've applied it in this case. And I think one of the points I'd sort of draw out on this slide is that sort of middle one, which is about codification US or UK law, because unlike most trade deals that we've seen, this is not legally binding in its normal way. So it's essentially both parties, both sides, the US and the UK, have got to give effect to that through domestic measures. I slightly wonder what happens in the world where your court system decides that the president now has power to impose these tariffs anyway. The sort of the UK interest in agreeing and giving effect to the EPD changes, but the political imperative in position is still there. And so there'll be an interesting dance, I think, depending upon what happens in your courts around what happens specifically with this deal. But yeah, it's very much designed. I mean, I think this slide is drunken slightly from the Kool-Aid of the White House announcement in terms of strengthening special relationships, but it was undoubtedly a good political position and outcome for both sides to be able to announce something a week or two ago when it came through.
And that's a good point, and not to belabor it, but you're spot on, and I think we all agreed to underscore that this is not a traditional trade agreement treaty, and it's consistent with what this president likes to do, invoking IEPA and moving quickly with no notice, no comment. I guess arguably, as you said, this didn't happen overnight, and you could also argue that this goes back years, as you noted, Andy. But the simple fact is that he was sworn in January, and then this deal was inked in early May. Um, and from what we understand, it's going to be the template for all the other so-called trade agreements that are reached with the other 90s countries. So, good point, and keep that in mind. And I think it's also important. And look, I would also note um, he redid NAFTA, called it the worst trade agreement in the history of the United States of America, and was intimately involved in crafting USMCA, NAFTA 2.0, and now he doesn't like that. So we're going to look at that coming in the not too distant future. There already are calls from the administration to blow it up, redo it, walk away completely. And again, and that's an actual trade agreement. So it'll be interesting to see how the US and the UK implement the EPD.
Yeah,
Right.
uh, completely. And I think what this slide does just sets out that sort of broad framing of the EPD itself. And I think given who we have on the call, that we don't need to talk about the sort of generalities of some of the stuff and the sort of entreaty to try and have a or build a new type of relationship or trading relationship. We can sort of get into the nuts and bolts a bit more speedily. So a lot of course, what we focus on is tariffs, particularly around certain sectors and certain commodities. And the next slide, I think, just shows a little bit of an outline of what that means for some key sectors and commodities. I don't think we need to necessarily dwell on that for too long. If we could just go to the next slide, that would be great. But because I think I mean, if you are in the aerospace, ethanol, aluminium world, you will be all over the detail and no doubt engaged closely with both UK and the US governments on it. What what's the impact? What's sort of the interesting bits to pick out of this? I mean, clearly there's some reductions in tariffs, um, but actually the UK has not sought to change its food standards, for example. So taking the beef tariff issues as a starter, the UK at the moment is trying to align itself. It's trying to complete the UK-India deal. It's trying to work with the EU partners, and we're seeing a sort of closer alignment of UK and EU trading relationships. And at the same time, trying to conclude the ZPD and to make sure that key sectors are not overly affected or the impact is mitigated for them of the US tariffs. So the UK is trying to ride a number of different horses, and I think whilst we're focusing on tariffs, it's also good and important to remember the wider regulatory environment we're in, and taking the sort of the beef tariff example. We're not seeing the UK food standards or regulations change dramatically at the moment. There will be, I'm sure, sort of the triangulation with the EU, US, UK discussions going forward. And similarly, we're seeing sort of very specific and not unsurprising quantities in terms of the quotas and tariff adjustments. It won't surprise anyone that 1.4 billion litres of duty-free quota for the US roughly reflects the entire import last year of ethanol from the US. So some clearly quite targeted specific things that are going to affect a few industries, but it's that sort of that bigger piece, which is around this new trading union, that ongoing relationship, as well as the specific points and how they interrelate with both this IEPA measures that the president introduced and also the Section 232 measures and investigations, which are talking around being converted to alternative arrangements. There'll be a bit of interplay there with what, if any, Chinese origin steel there is coming from the UK into the US. But I think essentially it's looking at that interplay, and it also gives us a bit of a flavour of where the president might go with other countries, which obviously is beyond my pay grade, but it's sort of interesting indications. So just a brief slide that I think covers some of those core commodities, but actually, uh, we know there's a lot of ongoing negotiations within the UK US context that haven't been picked up, and I think we just give a short list of those on the next slide. I'm rattling through a little bit because I think actually the the interesting or particularly interesting thing is as you were flagging Ashley and Shahin on the line, which is what's coming. What does this mean in terms of in practical terms for those grappling with the tariffs, with the retaliatory measures? We've not talked about the EU. I mean, the UK chose not to retaliate against US sanctions or US tariffs rather. The EU has said that it will, and has in fact imposed certain tariffs, which it's also suspended during this pause period. It's also brought a case before the WTO. We've seen what China has done. So the whole dynamic um, of world trade gets affected. So although we're talking about the UK-US deal, and there's still elements to be worked out, and as we're seeing from this slide, actually the big question is, what does the US and what do the US tariffs mean? Whether it's IEPA, whether it's 232, whether it's 301, what does it mean for those trying to do business, either right now or looking into the future? How do they plan around these sorts of pretty seismic changes?
Hmm. And I know we're going to tip it to Shaheen here. We do have at least a couple of questions coming in. We'll table that towards the end. I think we're pretty much on pace. It looks like we've got about 25 minutes to go. But Shaheen, this is a perfect setup now for you to kind of drill down on some of the questions that your clients are raising, and let's just see if we can be practical here.
Of course. And before I go further, I'd like to give everybody the CLE code. That is EPD 2025, EPD, like the word here in the title of this slide, 2025. So why don't we talk a little bit about what clients are asking and what they can do and what they should be anticipating when they're looking at this new deal and looking towards the future. And the first question that clients are asking is, okay, how is this going to impact my supply chain? What if there's a disruption? What happens when shipments are held for duty assessments, compliance checks, and document reviews, particularly when the tariffs are unpredictable, right? They're changing quite frequently, and a lot of times the people with their boots on the ground who are actually interpreting these don't necessarily understand the implication or whether even something coming in is compliant and what they're supposed to do. Are they supposed to hold it, or are they allowed to let it go? So importers and exporters themselves have a lot of uncertainty. And Andy, we were talking about this the other day about, you can look at this deal, but there are bigger ramifications here, right? It's not just about the US and the UK and the relationship between those and the EPD itself. So another question, and I'll sort of put this to Ashley here, is that you've got the elimination of the de minimis exception or treatment here. And what are your thoughts about, Andy or Ashley, what are your thoughts about how that's going to impact what people are going to do going forward in conjunction with the EPD and the US UK relationship?
So Shane, you've touched on a series of important issues here, starting with the upside down world in which the supply chain finds itself because of the inconsistency approach from time to time, and the fact that we've had on again, off again approaches to the tariffs. So, for those of you that are on and are importers, you're either directly dealing with logistics internally or you're outsourcing it to third parties. So we have every reason to believe, because we do a lot of work with transport providers, carriers, brokers, etc. Everyone is in the same position, unfortunately. And we're going to talk about in a little bit some potential options that you may have to mitigate. Unfortunately, not zero down. But we have seen, so de minimis is a very hot topic. For those of you that may not know, it is basically the baseline number, and it's currently at 800 USD, that you can move product in at a very reduced rate in terms of interactions with customs and the filing of formal documentations and entry prep, et cetera. It was at a lower price point for years, around 250 USD or so. And that meant that anything above that had to go through the more formal process, and you would need a broker primarily to help you navigate. The rise of B2C, the various platforms that are out there, frankly, COVID, where we were all at home staring at computers and purchasing stuff, that catapulted international transactions and cross-border activity, but it also increased the use of de minimis. Unfortunately, it's been abused, and it has been documented. So fentanyl and ways to get fentanyl into the country have been abused in terms of the de minimis. That is just a fact. So this is now very much upside down. It has created questions. We had heard that even some of the express carriers had hit pause in terms of postal shipments out of Hong Kong and mainland China. They've reversed that now. So keep an eye on that. Sheen, you also were raising questions about, is there anything that one can do at this point to soften the impact of the uncertainty surrounding tariffs? And one of the issues that we were seeing before the pause, and even frankly, right after the pause, and now I think it's happening during this 90-day pause, is folks looking to import product in, hold them in bonded facilities in the United States, or even overseas if there are certain facilities that are acknowledged and authorized by the U.S. Government, various agencies, for example, FDA, for food and pharmaceutical products. Moving them into these facilities to kind of weather the storm, to see what happens. And at the end of the 90 days, will there be an extension, or is this all going to go back to the reciprocal levels and everything's going to go through the roof again? At least have product in country. It's not formally cleared customs, but it's in a bonded facility. Obviously, this depends upon the product, its durability, whether or not it can be controlled from a safety perspective, temperature, et cetera. But that is something that we do know folks are looking into. And we have been told that there's been a spike, frankly, a lack of warehouse and distribution space across the country, but mostly on the East and West Coast, the main ports of entry. So you also talk about here, Shahin, and I can tip it back to you, looking at contractual underpinnings of the parties. Is there a way to maybe shift the burden, minimize the burden? This is the time to take a look at your underlying distribution, sourcing, manufacturing agreements to see if there are options that one can invoke here.
That's absolutely right, Ashley. That's what we're getting a lot of questions about here, because when we're looking at these issues, the question is really, what can I do and what can I do right now? We can't read the future. We don't have a crystal ball. We're doing the best we can to stay on top of an ever-changing, for lack of a better word, decision-making process and what's coming out of that. So a lot of clients are saying, okay, well, let's look at our contracts and see what they say. Because right now, we need to understand who bears the burden of the costs of these tariffs. Who bears the burden of determining the amount of them? What happens in terms of the shipping? If you have a product that you allow to be returned, especially in the D2C context, that's something a lot of people are asking about. If prices become or costs become prohibitively expensive, then what can you do? Are there price adjustment clauses in your contract? Are there force majeure provisions? We published an article recently about the use of force majeure provisions to get out of contracts that are basically prohibitively expensive to remain in. It'll remain to be seen whether or not this is a force majeure event, because it is a government decision, but it's not something like a pandemic or something that's entirely unforeseen. And a lot of times when you're looking at supplier and fulfillment contracts, those are between two businesses that are considered sophisticated, as opposed to a business to consumer contract, where a consumer might not understand that tariffs might be forthcoming, whereas companies that are involved in supply chain and transportation are more likely by courts to be expected to understand that this is something that is potentially foreseeable. It's not an unforeseen circumstance. I don't know if courts will adopt that attitude or not, or if that's how they'll come out. Some other things that companies should be looking at are the representations and warranties. What are the timing requirements? Are you going to be able to ship on time? Are you going to get the product on time? What happens if that doesn't go through? Are there termination rights available to a company that is receiving products, or if you're shipping products, are you at a risk where you've already shipped the product, it's delayed, it gets held up, and now you have a customer, your business customer doesn't get the product. Now, who bears the burden of that if now it's delayed? It's a delay out of your control, but it still is a delay. So one of the things, I mean, I'd like to talk about this in the contract of greater supply chain issues, including outside of the UK. But one of the things that I think companies need to start thinking about, in addition to evaluating who bears the burden and who bears the risk of what, is whether or not, number one, termination makes sense, and when it makes sense, and how it makes sense. For example, if you have a termination provision that requires some sort of action prior to terminating, or if it only allows you to terminate under certain circumstances, whether you should do so if you can in fact foresee an issue that makes the contract no longer commercially viable. And if you do look at termination, which companies might want to be looking at those now, even though we don't know what's going to happen, and an ounce of prevention is worth a pound of defense, or whatever the phrase is. So companies should be looking at that to say, okay, let's game tree this out. What's going to happen if this happens? Particularly because we are even if we don't have the details, we are seeing the writing on the wall. And if something changes, even if it isn't ultimately implemented, it might still cause uncertainty, to the point that we're talking about before, where the people who have the boots on the ground are still holding your product up, even if they're not supposed to be legally, right? It doesn't matter what the law or the EPD ultimately says. It matters what's actually happening at the border. It matters whether or not the product is getting on the trucks and getting to the consumer, the end consumer, whether that's John Doe consumer or a business customer. And to that end, if you are looking at termination and whether and when it makes sense to terminate, you should also be looking at the forum selection clause. What do we mean by that? Is, okay, are you going to be able to sue in a US court if you're a US based company? Or do you need to go to a UK court, a Chinese court, or somewhere else where it might not be as advantageous to you as a US company to be fighting your rights out? Do you have an arbitration provision? Is that something that you might want to invoke? Do you want to go into court? Do you want to be the first to file? We talk about this all the time, is that sometimes it makes sense to be the first to file, even if there's questions about what a forum selection clause actually governs, because if you are the first to file, then you might have the benefit of being in a US court. US courts in particular right now are more likely to want to keep the claims, just because they want to protect US trade and US tariffs, right? That's the whole point of this whole administration proceedings. And then the last thing too is indemnification. And I'm going to throw this back to Ashley and Andy a little bit here, because you do have there's a lot of times there's indemnification provisions, but they set out when like what circumstances there's indemnification obligation is going to be triggered, and what that procedure looks like. Do you have to provide an opportunity to cure? Do you have a certain amount of time to have an opportunity to cure? And what happens if you can't cure it? It's out of your control. And is the indemnification provision written broadly enough that if something's out of your control, that you can still sue for indemnification? So these are a lot of things that people are talking about. But one thing I know, Ashley, that we've been talking about with clients when we've been reviewing their contracts is that even if a manufacturing agreement goes sideways, there's other issues, right? With shipping or transportation. It's not just one contract between source and customer or business customer.
Absolutely correct, Shahin, and I thank you for teeing that up. You've covered a lot of ground there, but it's extremely important. We already are seeing the impact of the tariffs when it comes to transport agreements. So what you're hearing from my partner is a high-level set of commentary on the, if you will, underpinnings of the commercial agreement. So take U.S. importer who's sourcing from China. And they clearly have that agreement in place to produce widgets for a period of time covering X price point. But you also have to move product from A to B. And we've already seen this before the EPD. We had inquiries coming in from UK-based entities that some had physical US subs and affiliates, and others were pure B2C and were shipping to US consumers who were purchasing on their platforms. Some of the product came out of the UK. Some of it was already in North America, perhaps in Canada, perhaps in Mexico. Some of it maybe coming directly out of Asia. Most of it manufactured in China or someplace subject to relatively high tariffs under the Trump administration. So they were already starting to ask, is there ways to minimize, again, the impact? What about intra-company transfers? What about looking at other options like first sale, which is a customs doctrine that we don't need to have to get into right now. We don't have time as well. But to your point, Shahin, it's important to remember that you've got multiple layers of agreements, as you said. So on the transport front, you've got an agreement to consume transportation services for a certain period of time at a certain price point if you're the US importer, UK importer. And if there's a disruption, we've already seen it, either port congestion, lack of available container space, the carriers deciding to rationalize because there was a huge drop over the last couple of months when the reciprocal tariffs in particular were announced. People tried to front load, get product in before the tariffs, and then when the tariffs hit, we saw it firsthand. People were walking away. And frankly, we've heard the ugly stories of U.S. small and medium-sized importers that had built a business model off of sourcing from China that said, I can't absorb this amount of tariff, 145+%, and I can't impose it on the U.S. consumer because no one's going to pay for this widget times 3. And so they had no choice but to just walk away. And that has an impact on, as I said, supply chain operations. You heard Shahin talk about people considering walking away from their commercial contracts. The same thing with the transport contracts. We haven't really seen, at least to our knowledge, any of the lawsuits come online. And I think my own take is that just as we haven't seen a price spike in the pricing of the widgets themselves just yet, but all the talking heads say it's probably July, it's probably August. If the tariffs come back online at full force, we will see that spike. And the president has told people, don't increase your prices. Well, we'll stay tuned on that one too. So obviously a lot of ground that we're covering here. But the takeaway here is now's the time to take a look at your commercial contracts, your transport agreements, and dissect it, regardless of whether you're the provider of the services or you're the consumer of the services. You should take a look and see how tight that agreement is and whether or not you may want to consider revisions.
Right. I think that. Oh, sorry, Andy, go ahead.
I was just going to say, it feels like just pick up on Ash's point around the sort of the conflict and the reviews and all the rest of it. At the moment, it feels like there's a bit of a collective pause, a bit of an intake of breath, and people are trying to work their way through collaboratively, frankly, to try and figure out how to sort of manage and mitigate the commercial impact with the relationships they generally want to keep. It's just when it gets sort of existential, they have to think about some of the sort of the bigger options. But all the advice is sensible around what is how to plan for the future, because I don't think this is going away in whatever shape or form. We'll see different lawsuits, and I've got a question about what happens with some of those lawsuits. But we'll see different lawsuits and different issues. But it's going to be here in some way, shape, or form, I think. And just to state the obvious, which is, although we've sort of built this as a talk around the UK-US point of view, actually looking at the other market that we know and advise on well from Fieldfisher, which is the EU, from our sort of European offices, the big factor and the big question there, of course, is EU sanctions, or EU tariffs, which have all been paused. And all again, this is stating the obvious, all the things you've been talking about from a sort of US delivery point of view, we've been advising on and others will be thinking about from an EU perspective, or pick a market, frankly, South America, Mexico, China, and elsewhere. Because if there are reciprocal tariffs, and certainly the EU has come out fighting in that sense, then again we start to see that point around whether it's bonded warehouses, um, uh, how you navigate the sort of customs point to get through the eye of the needle, so that those are minimised, but you're still going to have a longer term impact and issues to have to deal with, and that's not going away. So those sort of contractual reviews, the negotiation around it, whether it's the product itself or whether it's the sort of transportation contracts that underpin it and the costs that go with those, all those things we are starting to see now happen a lot more actively than we had before, where I think at one point everyone just thought it was almost too difficult. They wanted to find a collaborative way through. That's true, and I think that is still going to be the best way. But people are also gearing themselves up to understand the impact and to prepare for that across the board. Sorry, Shahin, go ahead.
Oh, no, I agree with everything you said. And one thing when we're talking about what you do have control over is knowledge is power. And one thing that we're doing at Venable and Fieldfisher is tracking the what the tariffs are, the various tariffs and the various the status of those, including the litigation. So if that's something that you're interested in, having a copy of that tracker, please feel free to reach out to us. Our contact information will be here on this on the slides. But I'd like to also go forward. I know we don't have a ton of time about some of the practical implications of the tariffs that can happen and the delays. So what happens if your product isn't going to ship on time? There are regulations on the federal level by the Federal Trade Commission as well as the state level, including California, that require companies to ship within the advertised time period. Consumers nowadays expect everything to happen 2-day, overnight, or sometimes same day. And so companies need to make sure that they have whatever, that if they're making representations about how quickly they can ship something, that they're sure that they will get it there, or that they're complying with the requirement to provide notice, and in some instances get that consent by the consumer to the delay or offer them a refund. There was actually a lawsuit that was brought involving a shipping delay problem where a company did offer 2-day shipping and didn't do it, and the California regulators came after them. The next question that we are getting is, how do you manage returns, refunds, and money-back guarantees? A company must abide by its refund or money-back guarantee policy that's listed at the time somebody makes the sale. In other words, if you are offering a 30-day money-back guarantee, telling people if you're unhappy for the product for any reason, you have to ship it back within 30 days, then you'll get your money back. Then the question becomes, for example, 30 days from when? 30 days from when the customer places the order. What happens if I place the order on June 1st? Because there's a shipping delay, I don't get the product until June 25th. And what? Now I have until June 30th to initiate a return. I expect companies are going to start seeing issues surrounding that. So one thing that you can be looking at, particularly when you're thinking about what supply chain disruptions you might be experiencing due to the tariffs, is consider pausing, extending, or being really careful about how you couch your money back guarantee or your return policy. One thing that I recommend typically is that you start the clock for your money back guarantee or your return policy, not from the date that the product order is made, but rather when the product is received, so that somebody actually gets the full amount of time advertised to experience the product before deciding whether or not they want to return it. The next question that we're having is, what about pricing and transparency laws when costs increase? By that, we're talking about laws concerning drip pricing or junk fees. California recently passed the honest pricing law related to transparent pricing. That law requires companies to ensure that when they're advertising a price on a website or elsewhere, that that's the all-in price. You can't have the case where if there's a mandatory price that the consumer is going to pay when they place the order, that is disclosed for the first time on checkout page 2 or the final checkout page. If you do that, then you should be prepared for a lawsuit under California's honest pricing law. That's California Civil Code 1770. And we are actually seeing like 2 new lawsuits being filed on this every day for different types of fees. The next question that we're getting is, how do you label your product's country of origin when production changes? I know, Ashley, this is a question you're getting a lot, but I'm going to field it from the Made in USA standpoint. A lot of times companies want to advertise that their product is made in the USA, but it's particularly when people want to buy American. the Federal Trade Commission says that if you're going to make an unqualified made in the USA product, then the product must be all or substantially all created, sourced, and made, compiled within the United States. If you can qualify that language sometimes like made in the USA of globally sourced ingredients or other ways to qualify it. But we anticipate seeing an uptick in made in the USA or American made advertising claims, including by the Federal Trade Commission, which, although it is deregulating a little bit, does continue to bring cases based on this. What about subscription offers? Here's the problem. You offer something on a weekly or monthly basis, and your product is delayed. Your source, for whatever reason, the supply chain is now delaying the delivery of the product. You're charging somebody $50 a month to get something monthly. You're automatically hitting the card because that's how payment processing works. What happens if you hit the card on June 1st, the $50, but the person doesn't get the product until June 25th? And then you hit the card on July 1st because you're charging them, okay, my math is off, but you know what I mean, every 30 days, and they're still delayed. So is that a material change to the offer? Is that you basically violating your contract with the customer because you promised that they're going to get something in a certain cadence and you haven't given it to them in that cadence? And we say all of this not because these are theoretical risks, but rather we are seeing lawsuits on this, particularly on the junk fees and pricing class actions that I mentioned, made in the USA class actions, and subscription lawsuits. We're seeing an uptick in under California's automatic renewal law 17602. Those were previously not as litigated. We're seeing demands. We're seeing a ton of those, and we anticipate that class action plaintiffs are going to take advantage of these supply chain disruptions and the pain points for companies as a way to really profit off of that. For example, one of these junk fee cases related to packaging and shipping protection. If you're selling packaging and shipping protection, two things. One, it needs to be disclosed up front. As I mentioned, it can't just come on the shipping pay checkout page. And then number two is that if you are offering package or shipping protection, then make sure you can deliver on that promise, because you might not be able to deliver package and shipping protection if you know that something is going to be delayed. Same with here, made in the USA class actions. The big one here is that the Banks versus Bigello, the tea company, that was a $2.4 million settlement for a company that sold tea, advertised it as made in the USA, when in fact it was sourced from Sri Lanka and India. Because they had success in that case on such a large basis, we think that we're going to continue seeing that class action attorneys are going to take advantage of that. And I know we've got 1 minute, but here we go. Practical implications. Andy, what can we do now?
Yeah. Before, so I'll leave the words to stay there and we can circulate it. I think you also need to say it's for the CLE purposes, it's EPD 2025. I don't need to do that from the UK, but I'm happy to help on the US side, as ever, with our great friends. My one big question, and maybe this is just a cliffhanger, but is what happens next? I mean, I know that's the gazillion-dollar question, but it does strike me that, if the president is stymied through the courts on the tariff side on the IPA, does he go through Congress? Does he find some other way of affecting the big deals and changes he wants? I mean, that's the big uncertainty, but all of it seems to me not to be the point that at the top of the side there, which is don't despair, because there is that advice and support from your side, I know.
So Andy, a good point. We're being told by our tech folks that we can extend this to the point we need to wrap it up. So that's good. Maybe another couple of moments or so. On the question of where does it go from here, you're right to point out that the legal challenges, and like there's already 2 cases that have found that he has overstretched his legal authority. As I mentioned earlier, it's going to go to the high court, no question about it, and it will do so on a fast track. So I would say we should have at least some sort of clarity coming from the high court. I will not engage in conjecture as to what that may be. I think it's almost anyone's guess, and we could spend the next half an hour talking about this, that, and the other. But I do think that the administration is in uncharted waters. They're using statutory authority that has not been used in this capacity previously. Pre-IEPA, President Nixon did invoke a national emergency to get us off of the gold standard. That's the closest thing that we have. But this is all new. and it's highly creative. So the one thing I think that is certain is that they're not going to stop fixating on trade policy and the use of tariffs. If, in their view, the worst case is that IEPA is not available, I could see them mounting a two-front campaign. One, assuming that they maintain control of the House and the Senate, and we have a midterm batch of elections coming up next year, and I'm not going to engage in conjecture on that one. But there's a razor slim House majority, and it's not that much bigger on the Senate side. But I would not be surprised if he asks for amendments to IEPA that do what he would like to do now. Second, I think they will go down the 232 and the 301 and the other routes that require investigation and findings. That's going to frustrate them because it's going to take time. But as we saw the last go around, they did use those and they were used effectively. It just took time. So a long way of saying I do think that this is, as you said and Shahin did earlier, this is the new reality. This is the new normal, a phrase that we all became very apt at using during COVID. But this is where we find ourselves. And that's why I think the topics that we touched on today, and tip of my hat to the two of you, because we covered a lot. But Shaheen, you're touching on issues that frankly have not been identified, not from my perspective. There's been a huge focus on what does the tariff mean to me as an importer, but from the consumption side, the consumer angle, you're hitting on issues that I don't think anyone has really focused on, and you're spot on. People need to understand that things are changing, prices are going to increase, and there could be collateral impact outside of the traditional customs and trade and tariff issues. They're all tied together now.
Great. For my part, thank you very much for shepherding us all through this and for your counsel over the weeks and months.
And thank you all for joining. If you have any questions, you can reach us with our contact information or sign up to our mailing lists. And if you're interested in the document I mentioned earlier that Ashley's team is creating, please feel free to reach out directly.
Thank you everyone for attending, and thank you Shaheen, and thank you Andy.
Thank you.